Hi, my name is Charles Capouet. I'm an associate at Eversheds Sutherland and member of the state and local tax team in the Washington, D.C. office. And with me today is my colleague, Justin Brown from the Atlanta office.
Hi, Charles.
And we're here today to discuss the 2019 mid-year edition of the Eversheds Sutherland SALT Scoreboard.
For over 3.5 years, the Eversheds Sutherland state and local tax team has tracked significant tax cases, tallied taxpayers' wins and losses, analyzed the results, and provided a summary via our quarterly scoreboards.
We've had 3 year-in-review videocasts so far, 2016, 2017, and 2018. So Justin, how are taxpayers faring in this year compared to the same point of the prior 3 years?
So far in 2019, taxpayers have won 35% of cases. This is slightly better than 2018, where they had won 34%, but not quite as good as taxpayers fared in 2016 and 2017, where they won 42 and 41% of cases, respectively.
And taxpayers could still improve more this year. In the first quarter of 2019, taxpayers prevailed in only 23% of the significant tax cases, so it was a big improvement from the first quarter. Turning now to cases by tax type, taxpayers are prevailing in more sales and use tax cases this year than corporate income tax cases. Taxpayers prevailed in 38% of the significant sales and use tax cases, but only 24% of the significant corporate income tax cases.
A number of significant state tax cases were decided in the second quarter of 2019. The U.S. Supreme Court decided 2 state tax cases during this quarter: North Carolina Department of Revenue versus Kimberley Rice Kaestner 1992 Family Trust, and Franchise Tax Board of California versus Hyatt. In Kaestner, the U.S. Supreme Court held that North Carolina had violated the Due Process Clause of the U.S. Constitution when it attempted to tax the undistributed income of a trust, where the trust's only connection to the state was a North Carolina resident beneficiary. In Hyatt, the Supreme Court overturned its prior decision in Nevada versus Hall, and it held that an individual could not bring suit against the Franchise Tax Board of California in a Nevada court without the consent of California. Finally, the Colorado Supreme Court held that holding company of certain taxpayers were not required to be included in those taxpayers' combined returns. Charles, are there any other interesting cases from the second quarter you'd like to discuss?
Yeah, absolutely. For the spotlight in the second quarter edition of our scoreboard, we focused on Illinois tax cases. That's because Eversheds Sutherland is now celebrating the opening of its new Chicago office. One case in particular we found to be interesting was Mercury Sightseeing Boats, Inc. v. County of Cook at the Illinois Appellate Court. There, the court decided on the 20-day filing deadline for protests to the Cook County Department of Administrative Hearings. In that case, the taxpayer had filed after 20 days from the date of the notice, but before 20 days from the date of the receipt of the notice. The court first held in favor of the County Department of Revenue that the protest needed to be filed within 20 days from the date of the notice. But the court then determined that the Department of Revenue had actually actively misled the taxpayer by giving it bad advice as to the date that the filing was due. Plus, the department had also issued confusing guidance in writing. Ultimately, the court decided that the only proper remedy was to consider the protest to be timely filed and then send the case to be addressed on its merits.
Thanks for joining us today. Stay tuned for our Q3 and Q4 scoreboards, and also join us early next year for our 2019 Year in Review Scoreboard videocast. For more information, visit our website at eversheds-sutherland.com, stateandlocaltax.com, or our Salt Shaker app.
See you next time.